Hey everyone, we are back. Sure, turn your cameras on. Cameras, turn them on. All right, almost everybody's here. Any questions before we start this second half? Any questions regarding the previous half? Anything that you remember that while we're at it, you did not have a chance to ask? Drop it now and I'll address it. Hey, Brandon Ahmed said that you would ask a lot of questions. Waiting for those. He sent me a message. He says, Bruno, I'm preparing 1,000 questions. I'm going to be like Nina from my morning class. And Brandon will be the same. He's going to ask you so many questions. He's going to be the one interrupting your class all the time. I'm waiting for those. All right. If anybody's watching on YouTube, you can always post questions as well, and I will address it. That's your first question? How was my day? It was a great day. Always a great day. It's an amazing day. So, class in the morning, class in the evening, being able to help people in between. So, contracts and stuff. Can't get better than that. Love what I do. My kids had a trunk or treat today. Send me the pictures. So, very cute, even though I was not there, unfortunately. But very good, cute. Tina, how do you stand through all this? Like dealing with adults? Is that your question? Oh, how do I stand through all this? I think it's, look, I have a lot of back problems and it would be best for me to sit. But it's just, I'm glad you asked that question. The reason why I stand, it's a different dynamic. If I'm sitting down, then even the way I speak is going to be, okay, so today we have this and that. It's a different feel to it. I need to move. I need to be able to give those punchlines and create the movement as if you guys were here, right? For me, that's what it is. I cannot be sitting down. Like if I'm preparing a video, if I'm just doing a video for you guys to watch later on, that's one thing. But if it's being interactive, I need to be standing and be able to throw stuff at you and make it animated somehow. Okay, so that's why I stand, and then I deal with the pain right after. Yep. All right, Ruth says, I don't know if it's me, but you're blurry. I've been called a lot of things, Ruth. I've been called so many things. Never blurry. But it might have been something on the internet, or maybe the streaming server to YouTube, Ruth. So maybe that's what it is. Come back, give it a try, close, open, should work. All right. So if there's no questions regarding the chapter, right, we're going to move forward. So we're going to talk about involuntary title transfer. Involuntary, again, you are being forced. Involuntary is you being forced. People are taking the property away from you. How could it happen? We just talked about before the break. We talked about law of descent, which could lead to escheat. We've talked yesterday about abandonment, and it could lead to what we call adverse possession or easement by prescription. It could be through foreclosure. That means you did not pay your bill, and they came to take the property through a court action. We've talked about eminent domain. We're going to go back to all these in detail. But we talked about eminent domain, where the city, the municipality, right, takes over your property for the public good, right? Municipality could be county, also state roads. If they need to go into your property somehow, they can take it away. So government can take the property. And again, adverse possession. If you abandon, adverse possession will go, and Estoppel. All right, so we're going to start talking again about law of descent. We just talked about having a will. Hey, Ruth, if you're watching, let me know if I'm still blurry. Involuntary alienation occurs when the title holder dies without a valid will, right? Because the state determines, the state statute of descent and distribution determine who the heirs are and the respective shares of the estate that they will receive. In absence of heirs, meaning if they don't if they don't claim their rights, right? Title transfers to the state or county by escheat. Okay? Abandonment, as I was saying, the property has been abandoned for a statutory period, may also escheat to the state or county. And even the town. There's a lot of properties, I can tell you here in Newark, that they were deemed vacant or abandoned, and after a while the city of Newark just takes over, right? So if you guys find properties are abandoned, try to reach out to the homeowner, see if at least they're willing to sell the property, right? Instead of giving it to the city. Because the city, all they're going to do later on is auction the property anyway. The city does not keep properties. They want to get rid of properties. They want taxes, not the property. They want revenue, not the properties. Okay? If you fail to fulfill your obligations, as we said, you could lose your property by foreclosure. So if you don't pay the taxes or you don't pay your mortgage bill, you could lose the estate through foreclosure. Eminent domain, I already explained that. The city could take the property away from you because they need to build something that will benefit the community. Adverse possession. Adverse possession, squatter's rights, or easement by prescription. Somebody sees a vacant home, takes over, and after X amount of years, they can claim the right to use the property. Right? If you guys remember, it's an easement by prescription, right to use the property, and even claim title to the property. So let's go over this again. How can they claim legal title? How can I become the rightful owner of a property that I broke into legally, right? So, and the reason why I say broke into is because there's a legal process to do this. As long as you file the proper notifications, whatever your state requires, right? If you follow the proper procedures, getting into that home is not breaking and entering if it's deemed vacant. All right, hold on. Joel, but they paid you when the state takes the property? Okay, so let's go back real quick. Eminent domain, Joel is asking if they pay you. The answer is yes. They pay you a fair or just compensation. Okay? They do not just take the property away. They give you fair or just compensation. Now, fair or just compensation might not be what you're looking for, but they're not giving you 1 penny more, unfortunately. So back to adverse possession. How can I claim legal title of the property? Well, I got to be able to show a claim of right or color of title as a reason for possession. I have to have notorious possession, meaning I'm not hiding anything. There's no concealment. Everybody can see that I'm here. Maintain a consistent claim of hostile possession, meaning the owner did not give me any rights to stay here, but did not prohibit me either. So if I can show that throughout the period of time, I've been here without the owner's permission, right? Then that's called consistent hostile possession. And I must have continuously occupied the property for a statutory period of time. Statutory, depending on the state that you're in, could be 6 years, could be 10 years, could be 20 years, could be 50 years, 100 years. In some states, you even have to pay taxes in order to be entitled to the property. Okay, so Texas, for instance, has 3 different ways for adverse possession. One of them is paying taxes. The other one is using for farmland, using for agricultural purpose, and so on. Nope. Lula's asking if it has to be residential. The answer is no. The only type of property that you cannot do adverse possession against is municipal property or government property. Everything else, if it's privately owned and they abandon it, just step in, use it, take over. Simple. Follow procedures. Sorry, forgot to say again, follow procedures. Commercial as well. Like I said, the only thing you cannot do is government. The only thing you cannot do adverse possession is government property. Okay? So, can you take over the White House? No. Unless you become the president. That's it. Okay? Next. What is claim of right for adverse possession? Claim of right is based on adverse possessors occupying and maintaining the property. So again, if you guys remember when we talked about encroachment, I said this is the property line and this is where I have the fence, and I replaced the fence and I put it 1 foot over. Okay? I was there using the property. Everybody saw me using the property, and for the next 20 years, nobody complained. Nobody complained about the fence being 1 foot over. So technically, I claimed the right to the property because I was using it. Okay? So that's color or claim of right. Color of title is because there was an issue with the title. There's a defective title or received a title by defective means. But I occupied the property. So if I was not the legal owner to sell the property to you, right? But you now own it and you've been there for a certain amount of years, and somebody shows up later, you might be able to claim adverse possession saying, hey, I've been using and occupying for X amount of years. I don't care who sold it to me. It's mine. Okay, so that's color of title. The property was sold to me, right? And I've been using the property for prescriptive periods. So the court may hold the claim of right or claim of or color title to be a valid reason for possession. Either usage for a very long time simply by taking over, or something was sold to you that was not theirs to sell, but you've been using the property for the prescriptive period. Notorious possession, like I said, notorious possession means everybody can see what you're doing. You're not hiding in the basin, coming out at night to go shop and whatever. No. Your neighbors know that you're there. In fact, you invited them to a housewarming party. Hey, look at the house that I just stole. Legally, right? Of course, you're not going to say that. But there has to be a notice on the wall, on the door that says, my intentions are to take over this property. In most states, that notice has to be there for 90 days at least. Notice on the door, I intend to take over this property, right? And I'm not telling you how to do this. What I'm telling you is there's procedures to get this done. One of them is a big notice that says, this is my intention to do so. Okay? Now, right here it says, it is possible that such notice to prevail over notice of by recordation as a dominant evidence of legal ownership, provided that the possessor has occupied the property continuously for the statutory period of time. I don't know if you ever heard this, but possession is 9/10 of the law. This is in my hand. Prove that this is not mine. You understand? I'm holding it. I'm in possession of it. I've been using it. I have the bigger claim than you do. That's what we're talking about here. So the court may allow you to take over, right? Because you are in possession. After a certain period of time, of course. Now, as it says here, in some states, the possessor must have paid taxes over a prescribed period of time to obtain title. Otherwise, you might just obtain the right to use but not the legal title to it. However, if the possessor has paid rent of any kind, the claim of ownership might be refuted. So if at one point you were a tenant, then you had some type of permission to be there. Okay? How do we avoid adverse possession? As a homeowner, as a landlord, how do we avoid adverse possession? Well, it's as simple as once in a while, check out the property. Simple, right? If you know that, for instance, in the state of New Jersey, you need 20 years to claim adverse possession, actually now it's 30 years to claim adverse possession, then at least once every 20 years or 30 years, check out the property. In Florida, it's 6 years. So if you know in Florida it's 6 years to adverse possession, then once every 6 years or once every 5 years, at least, show up and check the property. You understand? So how do we avoid adverse possession? Go check your property and see if there's any trespassers. If there's a trespasser, then what do? Kick them out. Simple as that. Or, hey, I like what you did with my property. Would you like to stay? Sign a lease. So you either specifically tell them to get out or specifically allow them to stay there. That's how you avoid adverse possession. Okay? So you got to be very clear. Because like I said, when you move the fence over and I'm watching you and I don't say, hey, the fence is on my side. If I don't say anything, I'm watching you. But if I don't say anything, you still have the right. If I specifically allow you, hey, I know it's on my side, but it's okay for now, right? If I specifically allow you to be on my side, not a problem. It resets the adverse possession. If I see it and I don't say anything, then you have the right to adverse possession. You guys understand? We're good? Okay. All right, estoppel. So estoppel, we find this more in mortgages, but an estoppel prevents a person from claiming a right or interest that is inconsistent with a person's previous statements or acts. As a basis for involuntary alienation, the doctrine of estoppel can prevent an owner from reclaiming a property that was transferred under false pretenses. For example, an owner conveys a property with a defective title. Like I sold to you, right? But I knew there was an issue with the property, with the title to the property. I sold to you, okay? The grantor, the seller, is fully aware of the defect, but did not tell the buyer. That makes no disclosure to the buyer. The grantor, the seller, later cures the defect, so corrects the problem, and claims to be the rightful owner. So now I'm saying, hey, wait a minute. I couldn't have sold it to you before, but I can sell now, so I need the property back in order for me to sell it again. Sold is sold. You made a mistake, that's your loss. Okay? So what estoppel does is disallows the grantor's claim because of prior conveyance action. Okay? Since I had already transferred, then the grantee, the buyer, remains the legal owner of the property and benefits from the cleared title as well. Okay? So again, there's the warranty of season, right? When the property is sold or transferred, it does not matter who owned it or not. The previous one, right? Remember I did this? The previous one could no longer touch the property. I cannot reclaim the deed, even though I'm the one that transferred to you knowing that there was an issue. Okay? So I cannot reclaim the deed to correct the issue. Cannot. All right? Like I said, estoppel, you'll find more in mortgages. Because in estoppel, just like in a deed, when there's a transfer, we'll talk more about this when we get to chapter 7, but when there's a transfer from bank 1 to bank 2, right? It's like collection companies. When they transfer your loan to another bank, they have to say, from this day on, it stops. bank one from being able to collect. You understand? So because I transferred somebody else, it's the same concept. A estoppel certificate, the word is stop. So it stops me from being able to enter Brandon's house because now it's his. And in this case, it stops Bank of America from collecting on Brandon when they transferred to Chase. Chase is the one that's now entitled to collect from Brandon. So there's a stop. An estoppel means the previous person is stopped from it. Sorry, I just got a message here. Heather says, hi Bruno, just want to let you know I passed my exam today. All right, there you go. I want to thank you for your dedication. You have helped me tremendously. I used your videos and took notes. You're the best. Well, thank you very much, Heather. I appreciate that, and congratulations, and I wish you the best in this profession. If you ever need anything, you have my number, I think. If not, it's 908-418-8325. Make sure to reach out to me if you need anything. And my students, current students right now, are saying congratulations as well. All right? Very happy for you. This, by the way, guys, is the best reward I can get. Right? The fact that you guys pass and put the effort in, that's the best reward for me. Right? All right. So don't abandon us, Heather. Make sure you always come back and say hi to everyone. Anyway, so back to this real quick. Estoppel, as the name says, it stops somebody from being able to do something. In this case, from collecting, right, or having rights to something that they sold, right? Same thing as me giving you the phone, and then I ask you, hey, give the phone back. Oh, I gave it to you, or I sold it to you. Then I give it back. I'm stopped. Estoppel, okay? So remember that. If you ever see estoppel, somebody's stopped from doing something, cannot move forward or reclaim it. Again, best thing ever is getting these messages. All right, title records. Title records. There's something called chain of title. We have a recording system. Every state is a little different. And there's title evidence. So let's start with chain of title before I move forward. What is a chain? What is a chain? Let me know in the chat. What is a chain? Connection to something, linked system, something attached, the order in which something is recorded. Okay, so that will be chain of title. The word chain are links, attachments. And if a link is missing, here, would this stay on my neck? No, if a link is missing, then it would fall, right? So when we're talking about chain of title, is what links an owner, the current owner, the previous owner, to the one before, and so on. Okay? So when we're looking at, right here, when we're looking at chain of title, again, we're talking about what links the owners. Okay? Let's go here. State laws require the recording of all the documents that affect rights and interests in real estate in the public real estate records of the county where the property is located. These public records or title records contain a history of every parcel of real estate in the country, including names of previous owners, liens, easements, and other encumbrances that have been recorded. Deeds, mortgages, liens, easements, and sales contracts are among the documents that must be recorded. And other public records that affect real estate title are marriage, probate, and tax records. Now, these do not necessarily have to be recorded. Okay? Now, generally, every county has a recorder or a registrar that holds the land records. So Land records or public records are not at city level, they are at county level. Okay, so I'm in the Essex County right now. If I want to know about a property in Newark, where do I go? Essex County Registrar. Okay, if you're in Elizabeth, for instance, you're in Union County, then you have to go to Union County Clerk's office. So again, at county level, not township or municipality level. Now, title records, they serve a number of purposes, not the least of which is to avoid ownership disputes. So, Lula, your question before talking about deeds, should they be recorded? Yes. Do they have to be recorded? No. But yes, if you want to avoid ownership disputes in the future, the best thing is to put it into public records. Now, public notice. Public notice means that the title records protect the public by giving all concerned parties constructive notice. Now, everybody should know by now what constructive notice means, right? Let me know in the chat what's the difference of actual notice versus constructive notice. Actual notice versus constructive notice. Actual notice versus constructive notice. YouTube, you're free to answer as well. Zoom, let me know. Actual notice versus constructive notice. Okay. Brandon's answer. Cool. Okay. Anybody else? Giving an opportunity for everybody to answer. Come on, Brandon took the first step. That's it. Lula says the info is available to you. Constructive notice or public notice. Okay. Go at it. You're told. Danielle, actual means research or told. Constructive public records available. Actual notice your research. Okay. What's the difference between actual notice versus constructive? So we already have some answers. Give me a little bit more. Actual notice, what is it? Constructive notice, what is it? The ones that answer already, I'm not saying you're correct or incorrect. I'm giving a chance for more people to. Actual notice. Constructive notice. Yeah, type it, type it, type it. I see the hand on the keyboard. Type it. Say it. Okay. Come on, guys. Give me something. Come on. There you go. Denise. Actual, informed directly. Constructive notice was not received. Okay. Lula, actual notice, we have actual knowledge of something, learning something through direct experience. Okay. All right, cool. So, Ruth, don't worry about it. Sorry, I'm just answering YouTube message right now. Don't worry about it. That's why we're here. So remember, as the names, as the sentence says, actual notice, notice is disclosure. So actual notice means actually something you know or you were told. Okay? Actually something you know or you were told. That's actual notice. Where constructive notice or public notice is something that's available. All right? So again, as I gave the example before, when Lula was asking in the first half, when Lula was asking, well, what's the difference between them? Right? They seem very similar, and they are, because notice is that something is available. It's just one of them you were told, the other one you know it's there, right? So with the example that I gave Lula is, you guys know that these pages exist for this chapter, right? You had the chance to preview it if you wanted, right? But you didn't. So it was available. Now that we're going over it, you now have actual notice. You actually know what's on the pages, right? You guys know that our student portal has the replays of the classes. Did you watch the videos? It's up to you. If you did, then you have actual notice. Knowing that they're there, it's called constructive notice. You got it? Ruth, give me a thumbs up. Let me know. Here, you guys give me thumbs up. Great. Perfect. All right. By the way, I'm going to tell you guys one thing that I do not allow at all anybody to say is, oh, I have a stupid question. Oh, I suck at this. Oh, this is wrong. Oh, my. No, that's why you're here, right? If you weren't here to learn, right, that means you already knew. You're here to learn. So never say, oh, stupid question, right? Right? Never say that. Never think in your mind, I'm not going to ask a question because it's dumb. Never. Throw questions as bad as they could be. I can always find a reason of why they're actually good, great questions. Because the dumb question you have in your mind is probably the same question that the other 15, 30, 40, 50 people have in their mind. Simple. Okay? Just that I might know the answer. If you don't ask, it's tough for me to tell you what the answer is. All right? Is that a deal? You're going to ask a bunch of questions, please? You're going to participate, please? Great. Awesome. So that's why we are here. All right, buyer protection. Title records, so we're talking still about title transfers, right? Title records protect the buyer by revealing whether the property has marketable title, one that's free from undesirable encumbrances. The buyer is legally responsible for knowing the condition of the title. Since it is a matter of public record, recording a transaction also protects the buyer by replacing the deed as evidence of ownership. Question. What is something, sorry, I'm trying to see how much I can stretch here. There you go. What is something that's marketable? Something that is marketable. What does it mean to be marketable? Let me know. What does it mean, marketable? Something you're able to showcase or show off. Clear title, free from clouds. Something you can sell, able to be sold at both value and then money. Okay. Okay. So something that has value, that's good. Something that's able to be sold or traded, that's something marketable, right? If there's issues with it, can I market the property? Probably not. So a marketable title is one that's free from issues, free from clouds, okay? Other than those that we agree to. So I want to talk about marketable title real quick, and we might repeat this at a later time. But marketable title, when something is marketable, let's go over here, means that they potentially have no defects, right? Let me ask you something. How many of you, raise your hand, still go to the supermarket? Because I know nowadays we order stuff online too. All right, so the majority of you still go to the supermarket, okay? When you go to the supermarket, do you still buy milk? Does anybody buy milk? Okay, majority of you. Okay, cool. When you buy milk, Lula, you don't buy milk? That's okay. Okay. I don't buy milk either, right? But some people do. But it could have been something else, okay? You say vegan. Congratulations. I wish I could. One day maybe. Brandon says I buy plant-based. Shanice says I buy milk in bulk. She's the ultimate vegan. I buy in bulk. All right. So milk. Here's a question. I ask this in every class to figure out what marketable really means. Marketable title or marketable house. When you buy milk, and by the way, most of you will be wrong, so I'm letting you know right now, you will be wrong and it's okay, right? But when you buy milk, you already identified the brand that you want. So the brand, you got it. You already identified, like Brandon wrote, plant-based, okay? Or you're 2%, or you're lactose-free, whatever it is, right? But when you buy milk, after you identified all these things, and you got the price is right, you like it, what are you going to look at next? Let me know in the chat, what are you going to look at next? You found the brand you want, okay? You found the type that you want, like plant-based, 2%, 3%, whatever percent, no percent, lactose-free, with lactose, doesn't matter. You found all that. What is the next thing you're going to look at? Right? So wrong, 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 wrong. Okay, and wrong over there. Anybody else? I told you the majority of you are going to be wrong. I like the fact that somebody wrote reviews. Who wrote reviews? Brandon says, I'm going to look at the reviews. I'm at the supermarket. Let me go look at this milk and the reviews. Right? Competition, all that stuff. Okay, you're going to look at the sides to see what? The calories? Oh, the size. Size, got it. All right, on YouTube, we have Cheryl says sell by date and Ruth says price. See, Cheryl probably has been to my classes before. You guys never look at the expiration price. Never. You look at the sell by date. Why is it important to know the difference? Sorry. First of all, why am I talking about milk? And second, why is it important to know about sell by date? Right? Because just like real estate, milk does not expire. Milk transforms. Okay? Milk does not expire. Milk transforms. So milk has no expiration date. Milk has, you want to drink it by this date. You want to turn it into yogurt. You want to turn it into cheese. You want to turn it into desserts. Other desserts. Then after this date, they're good to go. But milk does not expire. It transforms. It's used for other things. Again, why am I bringing this in real estate? Because a lot of people want the milk as drinking milk. Some people want to go to that supermarket and say, hey, all the milk that passed this date, I'll buy it for 10 cents on the dollar. You understand? So people will pay full price, right? Turnkey, meaning I don't have to do anything to it. Other people will pay discount and fix the problems. Right? So I cannot buy it as milk. I cannot use it as milk to drink. No problem. I'll make the yogurt. I'll make the cheese. I'll make desserts. and I'll triple the value of the milk by tomorrow. Okay? So the majority of your buyers want something that's free and clear of any problems. They want turnkey. I buy the house, I move in, I rent or no rent, period. I don't have to do rehab. I don't have to worry about anything. Then you have investors. Investors are looking for the discounted prices with all the problems that need to be fixed because they're buying, right? As an example, they're buying 10 cents on the dollar and then they sell for 100 times that, right? As an example, right? So they will profit from fixing the problems. All right. So what is a marketable title? Whatever your buyer is willing to pay for, right? Or willing to deal with. Majority of the people, 90% of them, they want a marketable title free of undesirable encumbrances. Some people, like me, are always looking for problems that we can fix and profit from. Simple as that. Thumbs up? All right, cool. Because in the state exam or in the school exam, you're not going to see milk, but I want you to remember that rotten milk does have value. Rotten milk matters. Okay? Simple. Still has value. Everything has value. All things have value. You just need to know how to use that value. Okay? I see houses that are burnt down, destroyed, and people drive by and like, nope, not this one. I go there with some of my partners and look at it and like, okay, there's potential. Run the numbers. If numbers are okay, you're buying that destroyed house at the price of the land. And then you fix it up and sell it for a lot of money. And you make a lot of profit. Simple. So the more problems, most of the times, the better it is when it comes to real estate. That's good? Cool. Lienholder protection. Why do we record stuff into public records? One of the reasons is to protect the lien holder. Who's the lien holder? Because lien means unpaid money. Because lien means unpaid money, right? So, exactly. Banks usually. So the creditor wants some type of title protection. So I want to know that you are the owner of record if I'm going to lend money to you first. And I'm going to record the mortgage or the deed of trust, depending on the state you're in. I'm going to record it to let everybody know, hey, I'm the first mortgage. If somebody records after, they're the second mortgage. We were here first. Our flag is here. We're here first, right? So that's what a lien holder or creditor is and what why they require recording. It establishes lien priority. Now, going back to the chain of title, you guys have to give me a second because I cannot see a thing right now. Completely blind as a bat. But a chain of title basically is looking at, again, the current owner, the previous owner, and so on, and what was recorded against the property. So if there's a mortgage in the current ownership, if there's a mortgage, then it will be recorded on title. If there's a second mortgage, it will be recorded on title. If there's a third mortgage, it will be recorded on title. All right? So the chain of title refers to a succession of property owners of record dating back to the original grant of title from the state to private party. If there's something missing in the chronology of the owners, or if there was a defective conveyance, right? Defective, right here, marketable title, defects, right? If there's a defective conveyance, then the chain, right? I showed you the chain is said to be broken. And that results in a clouded title. Because I don't know who you are. Are you truly the owner? Because it only shows the record of somebody 20 years ago. You never recorded yours. So who are you? That's why we do title searches. Now, if you never recorded your deed, you have to file a lawsuit to quiet title. That means to clear the issue of what was not recorded. Okay? So a suit to quiet title is when we asking the judge, Your Honor, I have the deed, it was never acknowledged, and I need to record it. Okay? Your Honor, would you please allow me to file this now as if it was then? And you get what's called a judgment non pro tunc, which means Latin for now as if it was then. So we're recording today, but it's retroactive to when it was supposed to be filed. Okay, half of the stuff you don't need to remember exactly, right? So like the non pro tunc will never show up. It's Latin, it's the actual lawsuit or judgment, I'm sorry, so you don't need to remember that. But what happens in it with a suit to quiet title, you need to remember. A suit to quiet title is to fix the gap. So if there's a gap, I need to fix it, right? I need to put the chain back together so it doesn't fall, right? That's what it is. So the suit to quiet title is to clear that gap, to clear the record of any unrecorded claims. Like, for instance, your ownership. Now, how do we get to know that there's a clouded title or a clear title? We're going to pull what's called an abstract of title. Now, what is an abstract? An abstract is a summary. That's what you need to remember when you go through the exam. An abstract is a summary or a short history of all the major events that happened. All right? So look, here's the thing. I could sit down with you and say, the first thing we did was put an offer. After we put an offer, we started doing inspections. After doing inspections, we got the mortgage cleared. After getting the mortgage cleared, we got the title cleared. After all that, what do? We closed. In an abstract of title, all we want to know is that you closed. We don't want the whole history. We just want to know, okay, so the deed's transferred? That's what I want to know. You guys understand? Thumbs up. Abstract is a summary or a short history of what happened against this property, against these public records. Whoever's watching on YouTube, if you have questions, don't forget to drop them, okay? All right, so it includes a chronological, so it's in order, date order, of the property's title records and other public records affecting the rights and interests of the property. It includes the property's chain of title and all current recorded liens and encumbrances. Liens shows what's currently against the property that is owed by the current owner. Encumbrances, aside from liens, because a lien is an encumbrance, it shows also rights that other parties might have on this property. For instance, air rights, subsurface or mineral rights, and water rights. You guys remember these? Air rights, subsurface, mineral, or water rights. Okay. So these are rights that other people might have on your property. Okay. Now, the title abstractor or title company analyst conducts a search of public records called a title search needed to produce the abstract. Insurers and lenders generally require the search to identify title defects and ascertain the current status of encumbrances. So the lender wants to protect themselves. Are you really the owner? Again, do you owe this? Do you owe that? We just want to make sure that it's all clear before we give you money to buy the house, before we give you money to refinance the house, before we give you money for construction. All right? So before any lending, usually they ask for a title search. Before they give you any money, they want to make sure there's nothing against the property that will damage their position with their money. Okay? Recording system. I told you this is a short chapter, but a lot of information, right? Detailed information. recording system. There's no federal standard for recording. So each state prescribes procedures and requirements for recording in public records, the forms, the proper execution, acknowledgement, and even witnessing if needed. The following elements are evidences of title. Okay, so we have here the torrents system. We talked about it briefly earlier. Not many states use the torrent system, but the torrent system differs from other title recording systems in that the title only passes when the conveyance or the transfer was registered onto the title certificate itself. So if you guys remember, it's like the pink slip. There's the deed and the title will be attached. There's a certificate of title and the transfer with it. It goes in the same document. Now, encumbrances likewise have no legal effect until they are recorded. So, in effect, the torrents title record is the title itself. So there's no separate search for title. Everything is recorded and passed down in the torrents itself. It is not necessary to search public records to ascertain the status of the title. It is all reflected in the title certificate. To enter a property into the torrent system, a court action must first clear title by giving notice to all potential interested holders that they must express their claims. So they must verify, is this true? If so, then we record into the torrent certificate. If not, then it has to be disputed before we transfer the title. Title evidence says, since the value of the property is only as good as the marketability of its title, and by now you guys know what marketability means, right? The evidence supporting the status of title is a significant issue. To demonstrate a marketable title to a buyer, a seller must show that the title is free of, obviously, doubts about who you are. Remember, we said earlier that we could sell something that's not ours. That will be a defective title, right? But evidence of title is supposed to prove that you are who you say you are. Any defects must be free of any defects. So erroneous legal description means this is the property that you're buying, this parcel of land. That's what you're buying, right? And there's no ifs or buts about it. Meaning, my property is not on the neighbors and the neighbors is not on my property. What I'm selling you is this block right here, right? Patch of land, that's what I'm selling. And I have to clearly describe what I'm selling. There's no claims that could affect the value of the property or any undisclosed or unacceptable encumbrances. So surprises, that's what we're saying. There's no surprises when you buy this house. The four principal forms. Actually, let me ask you guys something before I go here. Which document evidences title? Which document is evidence of title? Can anybody tell me? Which document is an evidence of title? Which document is an evidence of title? All right. I got everybody saying deed. So far, the best one has been Joel. Written instrument. Deal with it. That was good. So a written instrument transfers property. It's called deed, the one that transfers property. But I'm asking, what is the evidence of title? And all of you are incorrect, and it's okay, right? There's only 4 types of evidence of title. You see, guys, a deed just shows that the property transferred. Remember I said several times, I can sell you this without being mine. Okay? I can come to you and say, hey, want this phone? You can have it, right? So a deed is not evidence of title. And by the way, everybody falls for this. For the past almost 5 years I've been teaching this. Everybody falls for this. The deed only shows that the property was from grantor and it was transferred to grantee. The property belonged to the seller and now was transferred to the buyer, supposedly. Okay? But evidence of title is showing, again, the links. What links the current owner to the previous owner? And there's only 4 evidences of title that are accepted. One of them is the Torrance certificate that we already talked about. It shows everything, like who was the previous owner and so on. Everything is on the title, right? We have the title insurance policy, because for a title company to insure, they verified everything and said, hey, it looks okay. Bruno could sell, no problem. And Brandon, you could buy, right? So there's an okay by the title insurance. They did full records and gave the okay. There's attorney's opinion and abstract of title. So instead of a title insurance company, the attorney reviews the abstract of title, that little history, and says, yeah, it appears to be good. So Brandon, if you want to buy, Bruno, if you want to sell, it looks like it's good, right? Or there's a title certificate, which is more for rural areas, and it's pretty much just an opinion, okay? So these are the 4 evidences of title. Let me repeat again that a deed proves transfer. Does not prove that you're the owner. Okay? A deed proves transfer. Write this somewhere. A deed proves transfer. Okay? It's a written instrument, like Joel was writing. It's a written instrument that proves conveyance, transfer. That's all. Okay? So the deed just says a transfer occurred. It does not say that you are the rightful owner. So for us to know who the rightful owner is, we do the Torrance certificate, which we just explained, or the title insurance. If there's no Torrance registration, title insurance policy is the commonly accepted as the best evidence in marketable title. So which one is the best? Supposedly Torrance certificate, because it's registered right on it, right? If that one does not exist, the second best is title insurance, because again, if they're insuring you as the buyer, you're kind of protected, right? So they're insuring. It indemnifies the policyholder against losses arising from defects in the insured title. All right, before I move forward, here I can see the thumbs up, so it's great. YouTube, can you guys tell me if you're good? Because everybody answered D, letting you know. Just like you guys, they all answered. So I just want to make sure you understand. I hate glasses. Anyway, Cheryl says, I'm good. Great. Perfect. Ruth, if you're there, and Stacy, if you're there, let me know. You guys understood the difference between deed and actual evidence of title. Deed means transfer. Evidence of title is showing or proving that you are who you say you are, pretty much. That you have the rights to transfer. Lula, great question. Great question. Let me address in a second. Ruth says, I'm here taking notes. Okay, you're taking notes. I just want to know if you got it or if you have questions. That's great. Let me know if you got it or if you have questions. Stacy, the same thing. All right. So there's a question here. Perfect. There's a question here. What if the property is paid for and there's no title insurance? So first of all, title insurance Usually we purchase at the time of closing. It's not an ongoing insurance, it's paid at the time of closing. It doesn't matter if it's paid for or not, because there's different types of title insurance. There's the lender's title insurance, so it's a mortgage title policy. There's the homeowner's title policy, and there's the leasehold title policy. So even tenants, long-term tenants, can purchase title insurance. So the being paid for means that the lender no longer has title insurance, the lender. But if you purchased your own as a homeowner, it protects you for as long as you're the owner. So the title is protected for as long as you are the owner. That's it. And protected against whom? Against previous claims. New claims, it's on you. Previous claims, like from the previous owner, they can never show up and say, hey, I'm the actual owner. So you are protected. Okay? Good? Okay. So, the common policy types, like I was saying, is lender's policy and owner's policy, which protects the respective policyholders in the property. Thus, a lender who holds $80,000 mortgage on the property will obtain protection worth $80,000 against the possibility that the lender's lien cannot be enforced. The owner's policy will insure against defective title to the extent of the property's initial or appreciated value. So remember, lender's policy or mortgage policy protects the lender up to amount of the loan. Owner's policy protects the policy for the amount of the actual transfer of title, right? Or new value, appreciated value. An owner's policy may have a standard coverage or extended coverage. Standard coverage protects against title defects as incompetent grantors, meaning you were not of sound mind when you sold it to me, meaning you were not of legal age when you sold it to me. You were an incompetent grantor. Okay? Invalid deeds, fraudulent transactions, or defects in the chain of title. So the insurance company protects against all of these. You guys got it? So if somebody claims to be the owner and sell it to you, and then later on somebody shows up, well, that was a fraud, right? That was fraud. It's an invalid deed, so therefore no. You are protected, and whoever comes to claim needs to go after the previous owner, whoever sold it to you. Extended coverage protects against liabilities that may not be of public record. Again, fraud, unrecorded ownership claims, unintentional recording errors, or unrecorded liens. So, standard or extended coverage, you need to know what you're buying at the time of closing. Now, if your property is paid for, Lula, going back to you, if your property is paid for and you don't have title insurance, can you get one now? Sure. They will do a title search and they will tell you, hey, we will insure up to from today on, right? Anything that shows up that was not on title yet, we will protect. Anything that's already on title, we will exclude from protection. Meaning if there's already a mortgage there, as an example, or if there's already a lien there, or anything, you have to deal with it. We protect up to today of any new issues, past issues you need to figure out now, if they're already recorded against the property. That's all it is. Okay? So if there's nothing against the property, then you're clear. Like I said, before issuing the title insurance policy, the title company does a title search to uncover defects in title and unrecorded breaks in the chain of title. So that's how they do it. They search and they say, okay, we insure based on this or based on that. We exclude this or exclude that. Simple. Attorney's opinion of title or attorney's opinion of abstract is simply an opinion when searching the abstract. Let me ask you something. If I tell you guys something, right, and I'm going to say, hey, in my opinion, now is the right time to hold on to your money, right, or sell anything you have, because the market is going to potentially crash and that's the right time to invest, right? If something goes wrong, I'm giving you my opinion as a friend in this example. If something goes wrong, can you sue me because you took action on my opinion? Can you sue me? The answer is no. Because as a friend, we were just talking and that was my opinion. If you followed me and you did what I asked you, what I was suggesting you to do, it was on you. You should have done your research, right? But that's a little different when it comes to attorney's opinion. Because an attorney's opinion is a legal opinion. Therefore, it's a professional opinion. Therefore, it comes with liability. It's just like me as a realtor now, not as a friend, but as a realtor or as a salesperson giving an opinion. Every time we give professional opinion versus personal, unbiased opinion, right? As long as we give professional opinion, we are now liable for the things we say. So the problem, I just want to show you guys the order that things are, right? We had here torrent certificate as being the best type of insurance. The best type of evidence. Title insurance was the second best if there was no torrent registration. The third one out of the four, the third one in the order is attorney's opinion of title, right? Because they do still research, but they're giving an opinion. And an opinion is not a proof or guarantee of clear title. So there's no protection for you as a buyer in the event it turns out to be defective. If I give my legal opinion, legal or professional opinion, can you sue me? At this point, yes. So this is not the most effective because somebody's just looking and giving an opinion. And then this one is the same exact thing as this one, but without checking the abstract. So title certificate is pretty much an opinion, period. I don't know, I did not check, opinion, okay? Joel is asking how you prove that the attorney gave you that opinion. Well, through representation, maybe you have something in writing. In this one, you don't even have to have it in writing. It could be oral opinion. Well, let's go to court. Who do you think the judge is going to believe? The attorney or the individual? The one that holds a legal title or a professional title and includes everything, or the individual? So it becomes a 50-50 chance, but because you are the consumer, the laws usually protect you more than the attorneys in this case, in this particular case, okay? Well, I know attorneys stick together, but the judge is not supposed to. But then again, guess what you're going to do? You're going to hire an attorney that hates attorneys. Always look for those. There's always one attorney that hates other attorneys. And I'm going to fight for you because I hate that type of people. Look, I'm a realtor and I hate realtors. Simple. I'm a realtor. I hate realtors. And one of the reasons why I'm teaching you guys is hopefully you become the type of realtor that I like, which is the one that cares about the client and not about the money. So yeah, I hate realtors. 90% of them. Anyway. So that was it as far as evidences of title. Again, we have torrent system or certificate. We have title insurance. These are the four evidences of title. Title insurance, attorney's opinion, and abstract of title, and title certificate or certificate of title. Okay, there's no guarantee. You guys have any questions you'd like to address? We're done with this chapter. I told you it was a very long chapter, a lot of information. The good news is that you ended early. Hey, Kevin, I didn't even know you were there. Good night. Hope you enjoyed. Hope it was good. All right, Cheryl has no questions. Cool. You guys have no questions? All right, cool. So with that being said, I wish you an amazing rest of your evening. I'll see you guys tomorrow at 10 a.m. if you're joining my morning class. It's the final day of the morning class. If not, then I'll see you tomorrow evening at 5:30. Thank you, guys.